Right. Yes, thank you. Uh, 10 minutes are never enough, but one should try to stick to the limit. My name is Ankit Malhotra. I'm reading my LLM at SOAS, the Felix Scholar. And this essay is largely part of a project that I've been working on, which has also been accepted as a book chapter. So there's a lot of writing on this. And with that said, the structure of the essay is followed. I've got a script as well for this particular talk, so I'll refer to that. Part two of the essay, first is just the introduction. The second part delves into the criticisms that have been leveled on the ICC, including the allegations of slow proceedings, lack of cooperation from the member states, and the ineffectiveness of the non-compliance procedures under Article 87.7 of the Rome Statute. There is further emphasis also being provided on the comprehensive reforms within the essay. Part three of the essay critically analyzes the findings of the independent research group, which is the crux of this essay, and discusses the statute and also the functioning of the ICC, the recommendations which have also been made with respect to British witness protection mechanisms and victim participations, to name a few procedures that the essay deals with. This is, of course, a very condensed version of the essay, which I'm happy to share that I have finished and now awaiting final comments from my supervisor and also from this August gathering. Part four also discusses the ongoing efforts to improve the efficiency, the transparency, public communication in response to the recommendations made. It also evaluates the procedures that have been taken by the ICC, such as to streamline the process and to make the court much more effective and also efficient. Part 5 discusses and synthesizes these analyses and offers a comprehensive review, panoramic review, which discusses the evolution of the ICC and also the reforms that it needs to undergo. But what perhaps most important is the engagement that the ICC has shown with an independent expert group. In some sense, this provides a challenge as well to someone writing a dissertation because you're dealing with two primary sources, which is not something which you are attuned to at the beginning of a bachelor studies and perhaps also at a master stage. That being said, the ICC's procedural framework is laid down in the rules and procedures of the evidence of the court itself. This ensures the fairness and upholds the international law principles which are held so closely by the ICC and also the functions within this. The ICC also relies on the states to arrest and surrender of individuals indicted for crimes, which might lead to crippling effects on non cooperation of states. This became extremely important in the case of al Bashir. In fact, ineffectiveness is also emerging in the court's bureaucratic pre-trial procedures. These are lengthy procedures which take too much time and also delays the idea of swift and quick remedies to those who have suffered tremendously from these procedures. The court's bureaucratic structure is one of the most important nerves that needs to be pressed and released in order to decrease the tension and also increase the vitality of a court of such importance. The OTP, or the Office of the Prosecutor, is also extremely important in this regard. So is the registry, which deals with the vast responsibilities and vital court functioning in this respect. Managing also of the victims and also those involved in these procedures is extremely important. And in this regard, the 2020 independent expert report becomes extremely important. And that becomes the beating heart of this essay and also the attempts that the essay tries to yield with. First step, which is the efficiency and effectiveness. Of course, I elaborate on the ICC and structure and all the extra aspects of the essay, but I don't want to discuss that here because that eats up time and also is not entirely relevant. So I will assume that that is known knowledge and dive straight into the essay, which discusses first of all the efficiency and effectiveness of the ICC, which is enshrined in Article 64.2 of the Rome Statute, which ensures fair and expeditious trials. These are also aligned with international human rights principles such as Article 14 of the ICCPR, which deals with fair trial and freedom under different statutes, but specifically under human rights statutes. These are communication channels which also need to be established. And an article which is recurrent in this respect is Article 86 of the statute of the Rome Statute, which creates the ICC. Moving on, there is also the discussion on transparency and improving public communication. This is an extremely important step, and I sincerely feel that the current prosecutor has played a seminal role in pushing forward the agenda of the ICC and also working in some sense as an evangelist. This Christian notion of evangelism is something which he has practiced very efficiently in working together with bringing states together and also acting as a hub or a nexus point for different projects and different documents which needs to be taken forward. He emphasized this in a recent, well, not so recent, but in October 2022, when he spoke at the London conference and elaborated on this role. He emphasized that the universities and the different policy-oriented persons ask for the ICC to do more, but to do more requires more funding, and funding is an option which we don't really have, or ambit which is still left uncovered. So we as an institution must together to bring states together for them to work and also emphasize this. This is, of course, just an anecdote. The hard crux of the intellectual stimulus in the academic research is all within the essay and the frame. But I just wanted to offer this as an anecdote of personal interaction and discussion with the chief prosecutor. The further aspects which need to be discussed and elaborated upon is judicial independence and integrity. And in this regard, what is important to note is the Bangalore Principles of Judicial Conduct launched in 2002. These also principles also offer ethical considerations and also underscore the values of impartiality, independence, and also integrity, amongst other things. The necessity to uphold jurisdiction and also judicial independence and integrity is something which cannot be overstated. This is also discussed in Article 42 of the Rome Statute, which says, and I quote, the judges shall not engage in any activity which is likely to interfere with the judicial functions and the confidence of their independence. This concept is also elaborated and emphasized in the Vienna Convention on Law of Treaties. I beg your pardon. Article 32, which emphasizes this role of governing states, not reading of conventions with the principles of good faith. Combined together, they provide a solid understanding and stimulation of the information that needs to be kept in regards to judicial independence. Furthermore, cooperation among states, as I've already stated, the functions of the ICC and also the Office of the Chief Prosecutor. This is in conjunction, also in addition to Article 17 of the Rome Statute, represents a key challenge and also a key gateway in fostering cooperation among states and also the members of the ICC. Moving swiftly to Article 68.3, which discusses victim rights participation. This, in and of itself, can become a topic for a dissertation, but I've condensed, or at least attempted to condense this into a part of this dissertation, because this showcases the meaningful participation in proceedings without interfering or infringing on the rights of accused, showcasing the delicate balance between the ICC and those involved. This becomes of seminal importance in 2005 in a report which advocated for the streamlining of processes and also ensuring victims' access to effective legal counsel and remedies. Of course, this is important and is discussed in the Diallo case and also in the Katanga case. These cases help create guidelines for wearable assets, and this is also discussed in the Lubanga case, which is the first trial before the ICC, and also highlights the importance of victims' participation and representation. The paper that I have written is also discussing these in depth. What I want to do through this discussion is to share the different aspects that I have touched upon and the most important legal aspects that I have touched. Now, if one were to look at the implications of this case study and the importance of formal and also informal oversight mechanisms such as this, it's informal because it comes from the outside, it reflects and looks at the institution from the outside, whereas there is a lack of formal oversight mechanisms within the ICC, which is where the lacuna exists and which is where this paper comes in. Uh, the overlooked aspects and the issues offer complexity, and there is over bureaucratization which is created within the reliability of the gaps, providing meaningful solutions, sometimes reducing the talk shop, which is rather ineffective in the action platform. The ICC requires capacity to uphold justice and also members within the global community. This requires ongoing introspection, reform, and adaptability. Progress has been made, but significant work remains to be done, and to ensure the court's continued contributions towards global justice, impunity, and eradication of any means that infringe upon the most known principles of international law, which are also enshrined as opinion juries, which is commonly known and understood. So, this expert report in this essay is a delicate dissection of both the practices and also the suggestions that have been made. What is also important and is also discussed within the essay is how the ICC reacts to the report and also engages with it, which is something in different courts and senses unheard of, which makes this discussion, which makes this parallel discussion all the more engaging, interesting, and discussion. I am at 9:22, so I do think that I should stop at this end and thank SOAS and also thank also my supervisor and also Professor. An honorable thank you to Professor Dr. Vonamensky, who's been a long-standing supporter of not just me, but also the family, and also has been very kindly looked at this essay, and also to Professor Matthew Craven, who's provided insightful comments on this. So 15 seconds left. So I should now stop. Thank you, Professor.